what attorney-client privilege really means in drug cases, or any case for that matter. Understanding confidentiality protections for clients in Houston. When you're facing a drug charge or any other charge in Houston, you may be nervous to tell your lawyer everything. That's understandable. You might be wondering, what if I say something that makes me look guilty? Can my attorney be forced to testify against me? Can the state get access to our communications? The good news is the attorney-client privilege is one of the strongest legal protections you have, and it's essential to building a solid defense. But it is also important to understand what the privilege covers, what it doesn't, and how to use it the right way. Today, I want to go over and explain what exactly the attorney-client privilege is, how it works, and how it protects your privacy, strategy, and future. Number one, what is attorney-client privilege? Attorney-client privilege is a legal rule that protects communications between you and your lawyer. Anything you tell your lawyer in confidence, whether in person, by phone, or in writing, is protected from disclosure. That means your lawyer cannot be forced to testify against you. Prosecutors can't access your confidential communications, and no one, not even the police, not the court, not even a jury, can hear what you told your attorney privately. This allows you to be honest, get accurate legal advice, and build the strongest possible defense without fear that your words will be used against you. Number two, why the privilege is so important. Specifically in drug crime defense, your lawyer needs to know the full story to understand what happened, to evaluate your legal risks, develop defenses, file appropriate motions like motions to suppress or motions for dismissal, negotiate with prosecutors, or prepare for trial. If you hold back critical details like how the drugs ended up in your car, who you were with, or whether you have a prescription, it may limit your lawyer's ability to help you. Attorney-client privilege gives you a safe space to speak freely so your lawyer can do their job effectively. Number three, what is protected under this privilege? In general, the following communications are covered by the attorney-client privilege: in-person meetings, phone calls with your attorney and not third parties, emails, text messages between you and your attorney, strategy discussions, potential hypothetical admissions of guilt, drafting legal documents, information related to plea negotiations. Even if you confess to a crime, your lawyer is not allowed to reveal that information to anyone unless it falls into one of the limited exceptions we'll discuss shortly. Number four, what is not protected? Attorney-client privilege only works when the communication is between you and your attorney or their staff. The communication is confidential, not shared with others. The communication is about seeking or receiving legal advice. And specifically, here's what's not protected. Conversations in jail that are recorded. Many jail calls are monitored. In-person visits are monitored. When those visits are between you and someone who is not your lawyer, it's all recorded and it does get used against you. Things you post on social media. If you admit to the crime in social media, that can be used against you. Conversations you have with friends or family. Anything you tell your lawyer in the presence of others, when those others are not employees of the law firm. Communications intended to commit a future crime. If you tell your lawyer you're going to commit a future crime, that lawyer should probably highly encourage you not to commit that crime. And if you persist, that lawyer has a duty to report the statements that you are going to hurt yourself or others. Remember, if you talk about your case with anyone else, that information is not privileged and could be used against you. Attorney-client privilege applies regardless of whether your lawyer is private or court-appointed. Public defenders are held to the exact same confidentiality rules as private attorneys. You can speak freely with them about your case, just make sure you're in a private setting and not discussing things over a recorded jail line. I frequently see this when someone in jail calls a relative to then three-way call a lawyer. That communication is not protected. There would have to be a direct communication with the lawyer and the client or the potential client. Number six, exceptions to attorney-client privilege. In rare cases, privilege does not apply. Here are the exceptions. The crime fraud exception. If you tell your lawyer about a crime you're planning to commit in the future, that conversation is not protected. For example, if you say, "I'm going to go sell more drugs tomorrow," your attorney may be legally obligated to report it. Third-party presence. If someone else is in the room when you talk to your lawyer, like a friend or your significant other, the communication may lose its privilege. The waiver of the privilege. If you voluntarily share or post parts of your conversation with your lawyer, like quoting them on social media or calling up a friend or family member from jail and saying you just met with your lawyer and here's the plan for what you're going to do, you've waived the privilege. You may waive the privilege for that specific instance, and it can be used against you. As long as you are talking privately with your attorney about past events or strategy, your communication is likely protected. Number 7, how to protect your privilege in a drug case. If you're working with a drug crime defense lawyer in Houston, here are some practical ways to keep your communications protected. Don't talk about your case over jail phones. Most jail calls are recorded and shared with prosecutors. Wait to speak in person or through your attorney's secure channels. Don't bring third parties to legal meetings unless advised by your attorney. Even a trusted friend or family member can accidentally destroy privilege if they're present during legal strategy discussions. Don't share your attorney's advice with others. What you tell others can be subpoenaed. What you tell your lawyer is protected. Keep communications between you and your lawyer only. Avoid forwarding emails, screenshots, or texts to outside parties. Ask your lawyer if something is privileged. When in doubt, ask. A good attorney will help you protect your communications from the start. Number 8, privilege lasts beyond the case. Attorney-client privilege does not end when your case ends. In fact, it lasts even after. The case is resolved, you've paid your lawyer, the lawyer-client relationship ends, you are no longer in custody. All of these situations, the attorney-client privilege still protects those confidential communications. Your past communications remain protected unless you choose to waive the privilege yourself. Number 9, what if the police ask about your lawyer? If law enforcement asks what you and your attorney have discussed, you have the right to say, that's protected by attorney-client privilege. I'm not answering that. Never feel pressured to disclose privileged conversations. You are legally entitled to keep that information private, and nobody can punish you for doing so. Bottom line, the attorney-client privilege protects you. Use it. The attorney-client privilege is one of the most powerful tools in the criminal justice system. It allows you to build an honest, effective defense without fear of being exposed or misunderstood. The more your lawyer knows, the better they can help. So use your privilege. Speak up. Be honest. Ask questions. And trust that your attorney is bound by law and ethics to protect your confidence. That's how real defense is built.